The claim by Amber Heard is for about $4.4 million.
Actor Amber Heard asked the Ninth Circuit to nix a California federal court's ruling in favor of her insurer, arguing that the court wrongly found she had no right to independent defense. The media and public were captivated in the summer of 2022 when Johnny Depp sued his ex-wife, Amber Heard, for defamation based on an article she wrote, which was published in the Washington Post. The case was decided in June of 2022. The jury ruled in Depp's favor, and Heard was ordered to pay $8.3 million. Heard then looked to her insurance company to pay the judgment. This is because Heard's liability insurance covered defamation. However, just because an insurance policy covers more than bodily injury and property damage and extends to defamation, that does not mean that coverage is always available when an insured is sued for defamation. It appears that Amber Heard's insurance company feels that coverage is not available for the judgment entered against her in part because of this insurance code section. Heard's insurance company had filed a declaratory relief lawsuit alleging that it has no duty to indemnify Heard because her defamatory conduct was allegedly willful, which cannot be indemnified under the California Insurance Code. According to the declaratory relief complaint against Heard, in the Depp versus Heard case, this heightened standard was applied. The jury determined that Heard's statements were with actual malice and awarded punitive damages. Heard had taken a $1 million liability policy with New York Marine in general. The actress also had another insurance policy with Travelers Commercial Insurance Company, which covered libel claims of up to $500,000. As reported by court documents, Travelers initially sued New York Marine in 2021 for half of what it had spent defending Heard, believing the actress was able to choose her own attorneys, and accusing New York Marine of wanting to use cheaper attorneys. It was due to Travelers' suit that New York Marine filed its own lawsuit against Heard on July 8, 2022. According to New York Marine, it should not have to pay Heard because she was guilty of willful misconduct. It added that California law says that insurers do not need to pay in the event of willful acts. The court gave judgment in favor of the insurance company, and now Amber Heard has asked the Ninth Circuit to nix a California federal court's ruling in favor of her insurer, arguing that the court wrongly found she had no right to independent defense at the cost of company.
Good morning, and may it please the court. Christopher Passage with McGuire Woods on behalf of defendant appellant Amber Heard, and I'd like to reserve 2 minutes for rebuttal.
Okay, counsel, keep track of your own time, please. Thank you.
Thank you. The district court's order must be reversed for 3 reasons. First, California has a strong interest in seeing California insurance coverage law and Section 2860 applied to protect California insureds and the rights of parties to California insurance contracts negotiated and executed here. Second, in light of Ms. Heard's well-pled allegations and New York Marine's admissions in this litigation, New York Marine's reservation of rights was a reservation as to Insurance Code Section 533. And third, because Ms. Heard's alleged conduct could be characterized as intentional in the Depp litigation, and because Ms. Heard's ability to obtain coverage turned on the characterization of that in that action, New York Marine's reservation on Section 533 triggered Ms. Heard's right to independent counsel under Section 2860.
Okay. To whom, I take it you're claiming that your client paid money to counsel that Marine should pay her. That's the only issue in this case.
Correct,
right
yes.
Now, right? You're not worried about indemnification for the judgment because that was taken care of.
Well, this case solely deals with defense.
That's right.
Yes.
So what we're dealing is with the defense costs.
Yes, that's correct.
To which of the very many firms in the case was this money paid?
By Ms. Heard?
By Ms. Heard.
By Ms. Heard, there were several different firms it was paid. It was multiple different costs, multiple.
Now tell me to the firms to whom it was paid. I don't care what amounts.
I don't have the names before me in the record right here.
See, here's my. Like, I'm trying to straighten out your claim in this case. And as I understand it, there was a period of time when Ms. Heard was represented by 2 sets of counsel.
Yes,
correct.
That's correct.
By Cameron McElvoy and then the various counsel hired by Travelers.
Correct.
So she couldn't have incurred costs because of the absence of second counsel during that time period for which you claim reimbursement, can she?
Also, so the problem is, Your Honor, is that not all of her costs were incurred. Travelers didn't pay fully for all of her costs.
I understand. With respect to at least, there's some point in time when she's got 2 counsels. So you're not complaining about absence of independent counsel in that period. What you're complaining about is that Travelers only agreed to pay half her costs. Let's assume there was a conflict, and it triggered the right to have independent counsel appointed. Travelers provided you with counsel independent of New York Marine, correct?
Correct.
So you had independent counsel. Now, you may have a complaint that New York Marine was somehow obligated to step up and cover the part of their bills that Travelers wouldn't cover. Put that aside for a second. I still don't understand. There doesn't seem to be any point in this case in which your client was deprived of counsel independent of New York Marine.
Deprived of counsel entirely? No. The problem.
Well, or any. I mean, there was no lawyer. There was no point in this case where your client was not represented by at least one firm completely independent of New York Marine, correct?
That's correct.
So what's the problem?
The problem is that Ms. Hurd is entitled to a defense between both. The problem is that
What do
she
you mean
has still.
between both?
Ms. Hurd is entitled to a defense from Travelers. Ms. Hurd is entitled to a defense from New York Marine. And just because she got a defense from Travelers, which wasn't a complete defense of everything that she had paid in the case, it doesn't obviate New York Marine's obligations under California law to provide a defense.
She's entitled to 2 lawyers, 2 defenses? Is that what you're telling us?
No, she's entitled to 1 full defense, and she has not obtained all of her fees that she incurred in the DEP litigation.
Well, she's not suing Travelers, right?
I'm sorry?
She's not suing Travelers.
That is correct.
So for
But isn't Travelers the person who owes the money under your theory?
No, because what Travelers did in this case, and what New York Marine did not do, is Travelers issued a reservation specific as to intentional conduct, and then when they did that, agreed to appointment of independent counsel. And that is what New York Marine did not do.
So if New York Marine had paid the other half of the bill for independent counsel, you would not be here, correct?
If New York Marine had paid all of its fees, we'd not be here.
No, just stop. Answer the question I asked, not the one you'd like me to ask. If New York Marine had paid all the, together with Travelers, had satisfied Travelers' counsel's bills, you would not be here, correct?
Correct. We'd have no.
Okay. So your complaint is not about the absence of independent counsel. Your complaint is about New York Marine's failure to reimburse your client for the amount of money she was out of pocket with respect to the people Travelers complained, right? Hired, right?
Yes.
I mean, whether you controlled it or not, your client has no liability resulting from the defense, except the payment of these fees. So I understand your argument that somehow they should have paid the fees, although it doesn't seem to be the argument you developed below or in front of us. But I don't understand the argument that she was somehow damaged by this reservation of right, because the only reservation was not to pay off the judgment, and the judgment's been paid off by somebody else.
And this is a $600,000 case, and remind me, the $600,000, is that correct?
That is not correct. There's obviously we don't have the record of specific invoices and total costs here before us, but it is more than it is a pretty substantial amount of costs that have not been yet repaid in this case.
Sorry?
It is a fairly substantial number of costs that have not yet been repaid in this case.
Yes. So how much? What's the number?
It's in the millions, Your Honor, by our calculations.
Where'd you get the number?
By summing up all of the invoices that we have.
Yeah,
that
well,
have not yet been
you're her
paid.
lawyer. I mean, it's not in the record. You might as well tell us.
No, it's through summation of the total amounts of the invoices that have not been repaid.
But they're invoices from
whom?
which firm?
From multiple firms, from multiple defense.
Which multiple firms? There's only 3 firms in the case. So tell us which firms they're from.
I don't have the names of those firms.
Well,
firms
they
right here
can't be
before
from
me.
the McAvoy firm, correct?
Well, no, the McAvoy firm was paid for a portion of it, but I believe it was only things other than the McAvoy firm.
Right, because you weren't entitled to have stuff reimbursed before you tendered the case.
Correct, that's
and
correct.
after the moment you tendered the case, you had 2 sets of lawyers.
Yes.
Okay.
Heard.
But
Mr.
I'm
Gentry.
still talking about indemnification, and you're missing me here. There's only 2 possibilities. Maybe she had another set of counsel and would have won, in which case she would have had no personal liability. Or with another set of counsel, she still would have lost and there would have been a judgment to be paid. It was paid. So I'm still trying to figure out how this conflict of interest led to any monetary loss on your client's behalf, other than paying for, let's say, the Charleston firm.
Good morning, Your Honor. Cheryl Orr on behalf of New York Marine. I'd like to clarify a couple of things for the court's edification. The claim by Amber Heard is for about $4.4 million. So
So
it
what
is
is
in the
that
record.
total amount that you're referencing that
This
is at issue?
This is the 4.4 million is the delta between what Travelers reimbursed Heard for her independent counsel fees for all of the independent counsel she had in representing her in the Depp lawsuit. The $600,000 figure that we reference is a different amount. That's the amount that that we paid Travelers to represent 50% of the share.
Are you saying that the difference between 4.4 million and 600,000 is the amount that is being sought in reimbursement in this lawsuit?
No. Travelers, in the Travelers case, Travelers was seeking some amount. It wasn't expressed. In our cross complaint or counterclaim in the Travelers case, we asserted that we had paid over $600,000 to Travelers as a 50% share of the independent counsel fees for some period of time at that point during that period of time of the defense.
And so they're claiming that she was out of pocket some amount more than that 600.
Right, but this $600,000 was just a 50% share of what Travelers had already paid. Now, what Travelers paid, the total amount that Travelers paid was probably in the, it's alleged to be in $5 million. But this 4.4 is above the 5 point. Well, first of all, when Heard retained her counsel, Mr. McAvoy, she retained Mr. McAvoy.
I understand. You retained Mr. McAvoy when the case was tendered. And
No,
you,
we just agreed that he could continue to represent her.
agreed.
He
And
did
you
retain
retained him.
before.
He had been retained before by Heard.
And they're not complaining about your failure to pay him.
Now, at that point, they said, when we issued the reservation, it's a general reservation, all we said is, we may not indemnify you. We
Right.
may not. Then, at this point, Travelers had already assumed the defense.
Same time roughly the
Before
same
us,
time.
okay? So Travelers then assumed the defense. At that point in time, the insured does not have an obligation to, or a right to a further or second
I'm
defense.
fine with that. Okay. If Travelers won't pay for that counsel, we don't have any obligation to either. And that's my difficulty with the
But
case.
Travelers did pay for that counsel. And she admits in paragraphs 25 and 26 of her counterclaim that she received a defense from Travelers. Once you receive a defense from Travelers under 2860, you do not have a right to a second defense from any other insurance carrier. 2860F limitation. This is fully recognized under California law that when there is a reservation of rights and it implicates the right to, I'll call it independent counsel because that's what the cases call it, you are only allowed to receive reimbursement for the panel counsel rate up to that cap. And no matter how many insurance companies also insure you, you are not entitled to get more than that. That's the San Gabriel Water case. And we cited these cases at pages 65 and 66 of our brief. And this was argued in the trial court in the
But not
motion.
decided on that basis.
It was not decided, but it is the key to answering your question because this is rote law that when an insurance company accepts the defense of an insured, and there are multiple other insurance companies out there that may owe a defense, the insurance company that steps up and assumes the defense under 2860, that insurance company then has the right to seek contribution from the other insurance companies for what they pay to because we cite the cases, the Ringler and Associates case is a perfect example. That's a case where an insurance company has a duty to defend, another insurance company has a duty to defend, one accepts, and then the other cannot be sued for breach of contract or bad faith like Heard has sued here because she's already receiving the defense, she's already receiving the peace of mind, and she's only entitled to a single defense from one insurance carrier. An insured is entitled to a defense, and if the insurer appoints defense counsel, it will be free because they appoint their panel counsel and they pay panel counsel who will agree to accept the lower rate. I'm happy that 2860 applies because I believe the 2860F rate limitation and the San Gabriel case says that a California insured can never expect to have more than a panel counsel rate when she hires independent counsel. She gets independent counsel, but she has to pay for the difference if she doesn't want panel counsel.